What about the other two motions?
I should move them at the same time?
Yes.
Thank you.
I've made an order consolidating the hearing of the three motions.
Okay. The next one, my Lord, is an application, a notice of my commitment to file a final written address, which was dated the 11th day of November and filed on the same 11th day of November. It is accompanied, my Lord, by grounds upon which this very application is predicated, and the grounds are 4 in number, my Lord, and I went on to elucidate the body of objection and then the constitutional foundation and jurisdictional limits of this very court.
You all have the grounds stated?
Yes, my Lord, you may. Ground number 1, my Lord, states here, the defendant, having called evidence through cross-examination of all the complainant's witnesses, has given evidence and entitled to the summation of those points through a final written address. So I have actually entered my defense, my Lord. What I did not do is to call a witness, because the evidence tendered by the prosecution were surgically demolished. The right to ground 2, my Lord, the right to final address is a fundamental constitutional right integral to fair hearing under Section 36, Sub 1 of the 1999 Constitution, and no court has jurisdiction to unilaterally order its waiver without the express, informed, and voluntary consent of the right holder, which is myself. The third ground, any order directing or implying a waiver or final address constitutes a breach of fair hearing, my Lord, which goes to the root of the court's jurisdiction and renders the entire proceedings a nullity. The court, ground number 4, the court lacks jurisdiction to extinguish or dispense with mandatory procedural stage of criminal adjudication, such as a final written address, as this would amount to an unlawful assumption of power beyond the limits prescribed by the Constitution and extant laws. And ground number 4, for reference purposes, my Lord, Section 36(1) of the 1999 Constitution, which I'm sure the court has taken judicial notice of. Those are my grounds, my Lord, in respect of the notice, seeking this court's discretion to allow me to file my final written address. Having entered my defense, I move that this very notice be adopted, my Lord, in its entirety. The third and the very last one is the issue of bail, my Lord, the issue of bail. This was dated the 17th day of November 2025 and filed on the 17th day of November 2025. It's a very simple one. It is a notice, my Lord, brought pursuant to sections 35(1), 35(4), and 36(12) of the Constitution of the Federal Republic of Nigeria, 1999, as amended, sections 158, 162, and 165 of the Administration of Criminal Justice Act 2015, and under the inherent jurisdiction of this very noble court, I am praying, my Lord, for an order admitting me on bail, the defendant applicant to bail on liberal terms, pending the determination of the invalid charge presently before this court, an order, my Lord, declaring that the continued detention of the defendant applicant, my humble self, in the absence of a valid subsisting charge under a written law in force, is unconstitutional, null and void, my Lord, and for any other orders that my noble Lord may deem fit to make under the circumstance. This is supported by an affidavit of 9 paragraphs deposed to by Prince Nnamdi Kanu, and also by a written address which I urge my Lord to accept its